Be ready. 5 seconds.
It may be mentioned here that the plaintiff's respondents filed the aforesaid partition suit claiming half share in the suit property. The said suit was decreed and the appeal filed by the defendant numbers 1 to 5 was dismissed. From perusal of the impugned judgment and final decree, it appears that the trial court has considered all the questions raised by the appellants and did not accept the same on cogent grounds. A first appeal to this court from the order of the subordinate judge is really in the nature of a second appeal, in which only questions of law and principle can be considered. It is quite impossible for the court to go down to the area in question, inspect the land, hear the various objectors, and in fact review the decision of the commissioner on fact. The power to review the decision of the commissioner on the facts is a matter for the subordinate judge, and his view of the facts ought to be final as a first appellate decision on fact. The High Court should only interfere when it is shown that the judge in his Patna High Court FA number 344 of 1979 decision has gone wrong on some question of principle in making the final allotment and in drawing up the decree. It may be mentioned here that another division bench of this court held that where a commissioner is appointed to effect partition, the power to review his decision on the facts is a matter for the subordinate judge who passed the final decree, and his view of the facts ought to be final unless some question of principle in making the final allotment and drawing up the decree is involved. On the contrary, no decision has been cited before this court by the appellants. Therefore, the division bench decision is binding on this court. The points raised by the learned counsel for the appellants are essentially question of facts which have been considered by the pleader commissioner as well as by the trial court. Therefore, in my opinion, the points raised by the appellants have got no merit in this present appeal, and on those grounds the impugned judgment and final decree cannot be set aside. In the result, I find no merit in this first appeal, and accordingly this first appeal is dismissed. The impugned judgment and final decree is hereby confirmed. No order as to cost,